All rise. Judge Vanderbeek Court is now in session. Judge, this is case number JVB 1034, Thornton case.
Thank you.
You're welcome.
You all may be seated.
Ladies and gentlemen, buckle up. This case is about to get messy. We've got a father fighting for financial support, a mother completely MIA, and a teenager caught right in the middle. Mr. Thorne walked into court expecting fairness, but will the law actually back him up? Or is he about to slam into a legal brick wall? Let's dive in.
Thornton,
Yes, ma'am.
you're back. How are you doing?
Oh, not as well as I'd like to.
Okay, all right. You brought this case before the court. What's going on?
Well, Your Honor, there's been some significant changes in my situation. And as you can see, Ms. Hernandez is not here today. And I have custody of the boy, and I have been, making our arrangement payments to her.
Okay.
But since the boy has come to stay with me, he's gotten himself into a lot of trouble.
Okay. What kind of trouble?
Pause for a second. You can see right away Mr. Thorne isn't in great spirits. And honestly, who would be? He's raising his son alone, drowning in medical and legal bills. But here's the catch. He agreed to no child support during mediation. And the law? It runs on structure. Unless he can prove a significant change in circumstances, his case looks shaky. So here's the big question. Should a parent still be financially responsible even if they've moved away? Drop your thoughts below.
Chase?
This is AJ, right?
Yes.
Okay.
And Miss
Since that time, nothing has really changed with the living arrangement. AJ still lives with you,
Yes, ma'am.
and you still have not been paying child support. You've been making the back child support payments.
Yes, ma'am.
Okay. Other than AJ getting in trouble, what else has happened? Like, what has changed?
Well, she has moved out of state, quit her job, so her insurance no longer covers him
Okay.
in that aspect. And, the court costs, fines, and due to that accident, there was a lot of damage in which he's liable for, or I am, and it's almost impossible.
Okay.
For me to,
But AJ was double insured by both of you, right?
yes.
Okay. Here's the issue. In order to modify any type of child support situation, whether you receive child support or you don't receive,
Whoa, did you catch that? This isn't just about unpaid child support anymore. Now we're staring at a full-on criminal mess. AJ, the son, is in serious trouble, and dad is stuck footing the bill. To make matters worse, insurance companies don't cover criminal acts. So not only is Mr. Thorne drowning in costs, but his insurance might bail on him completely. What would you do here? Let AJ face the fallout alone, or keep fighting for some kind of help?
what's called a material and substantial change. That means that AJ's living arrangements would have had to have changed. Something about his educational expenses have changed. Something about mom's income would have had to have changed. But in you guys' case, you agreed in mediation to no child support. So to go from no child support to receiving child support, you would have to fall in one of those categories for a material and substantial change. And based on what you said, you really don't fall into one of those.
That's very disappointing. So she's just free of any obligation? I mean,
Well, I wouldn't say she's necessarily free, but remember, you all did come to an agreement in mediation to no child support. So in order to start receiving child support, you would have to show that something has changed. So let's say, for instance, at the time of mediation, AJ still resided with her, now he lives with you, then we can entertain child support at that point. But nothing has really changed since you guys have gone to mediation. Therefore, you wouldn't be entitled to receive any child support, unfortunately.
I understand.
And here's where it gets even tougher. Mr. Thorne is desperate for relief, but Texas law isn't giving him much wiggle room. Mediation agreements are binding, and unless there's proof of a major shift, like changes in income, living situation, or the child's needs, the judge's hands are tied. Still, it makes you wonder, shouldn't a parent always contribute when their child is in crisis? Let us know what you think. Clip 5. Yikes, that's reality hitting hard. Mr. Thorne was hoping for relief, but the law is crystal clear. An agreement is an agreement. Morally, Mom may not be off the hook, but legally, she doesn't owe a dime. This is one of those tough moments where fairness and legality don't line up. So, what do you think? Should the law be more flexible in cases like this?
Witness in the Thornton case. Dad was appearing in court for the first time. He and Mom settled at mediation for no child support. Well, now he wants Mom to pay child support. Well, under Texas law, in order to modify child support, there has to be a material and substantial change. For example, there has to be a change in the child's mental needs, educational needs, a relocation of the parent, or an increase of income. None of those things took place in this particular case. Everything pretty much remained the same. Therefore, he was unable to get any child support.
And that's it. Case closed. No material change, no child support. The ruling stands. Mr. Thorne just learned the hard way that once you sign on that dotted line, getting a do-over isn't easy.